And that was what raised the confidence in the people that the election of 2023 was going to be free, fair, credible, and that everybody who partakes in it will come out satisfied. Unfortunately, on the 25th of February, INEC somersaulted in all the things they promised. Professor Yakubu Mahmoud and Festus Okoye, the mouthpiece that went around telling people, trust us, electronic transmission is mandatory, we will do it. Mahmoud even said he will have television on top of his head, and as he's reading the manually collated results, you will be watching the electronically transmitted result. And you know what? That is what the law says. Electoral Act 60 subsection 5 is very clear that after the election you transfer to the collation system in a manner prescribed by INEC. And in paragraph 38 I of the INEC regulations and guidelines for the conduct of election, INEC was very clear. On completion of the polling units voting and the results procedure, the presiding officer shall electronically underline, transmit the polling unit results to the collation system and use the beavers to upload the scanned copy of the form EC8A, that's the polling unit result, onto the IREF portal for the public to see. And INEC made it clear, following the dictates of Electoral Acts section 64 subsection 4AB. He said you should not collate, you should not announce the result except you verify the authenticity, that's the correctness of your manually generated result and the number of accredited results on from EC8A with the one transmitted in the collation system. And INEC was clear in paragraph 48 A and B that you can only collate when those transmitted results are there for you to verify their correctness. Now, what it means is that the law has outlawed sole manual collation of results. So what you have now is you must verify the authenticity of the manually collated result with the electronically transmitted results. This is the position of the law. And INEC said in collation of the result, after every collation center, the collation officer must transmit to the collation system for the next collation center of the next level to use to verify. And I'm talking of paragraph 50XX, paragraph 50XI, paragraph 53XII, and paragraph 54XII of the INEC regulations and guidelines for the conduct of election. Each level, when you finish at the ward level, collation officer transmit to the collation system. That's what you call when you hear INEC server, when you hear database, when you hear National Electronic Register of Election Results, well, by whatever name you want to call it. The law says without beavers there is no election. Section 47. Beavers is simply the electronic device with which you use to accredit people through facial recognition or fingerprints, to store results and information, to transmit. Say without beavers there is no election. INEC made it clear in paragraph 38 III. When you finish, you take the manual results and the beavers to the collation centers for the use of the collation officers. These are the position of the law. What did the Presidential Election Petition Court, what was their judgment? That transmission of election electronically is discretionary. So the court is telling INEC what the law is. It's not the duty of the court to make laws. Their duty is to interpret the laws. The laws are already made. INEC itself went around the whole Nigeria telling us the position of the law. And they gave us the paragraphs. They gave us the Electoral Act. And then the court is telling you another law. I don't know wherever they use the word discretionary. I don't know wherever they use the word may. Everything about section 60 subsection 5 is shall. Everything about section 64 subsection 4AB is shall. Everything about paragraph 38 I is shall. Everything about paragraph 48AB is shall. Where did they get the discretion from? In any case, assuming without consuming, you, the court, said INEC has the discretion to determine the mode of transmission. And INEC has chosen, assuming INEC exercised the discretion to give themselves the law that mandates them to do it in a particular way. And you, the court, again is coming to say it's discretionary. Look at the contradiction. Assuming by their own judgment, transmission is discretionary. And then the court agreed. INEC said they would transmit electronically. The court agreed. INEC did not transmit electronically. And the court now came from nowhere and said it doesn't matter. So either way, the judgment is illogical. It does not flow from the law. And Supreme Court has made it clear. Oyetola and INEC. In other words, if you like, call it Oyetola and Adeleke. The Osun Guba election. He said, as the names depict, and I'm talking about page 24 of the lead judgment by Emmanuel Akomai of the justice, is the justice of the Supreme Court. He said, as the names depict, the collation system and the INEC results review portal, that's IREV, are now part of the election process. He said, so the polling unit's results transmitted to the collation system are now the means with which the collation officer verifies the polling unit results for the purpose of collation as the need arises. This is Supreme Court judgment. And I said page 24 of the lead judgment by Honorable Justice Emmanuel Akomai, Justice of the Supreme Court, JSC. I wonder why the court was citing the judgment of Federal High Court to compare it, to subordinate it with the judgment of the Supreme Court. Here the Supreme Court again. The polling unit results transmitted. Use the word transmitted. Do you transmit something manually? Transmitted to the collation system is now the means with which the collation officer verifies the polling unit results for purpose of collation as the need arises. That's all. That has secured our Electoral Act 2022. Yet, the PEPC, in their own judgment, said it's discretionary. Then what do you use to verify the manually collated result. Then what is the essence of Electoral Act 2022? Because that is the whole essence. Recall that when they were enacting this law, they left out the issue of electronic transmission of result, and the whole Nigerians rejected it. President Buhari rejected it. They had to go back to put it. And recall, the reason they did not mention the specific card reader is they said, look, if we mention any specific type, when technology increases and advances, and that one is obsolete, INEC will now need to amend the law. So let us leave it to the discretion of INEC, so that they wouldn't need to come back to us to amend the law. They would just deploy the new technology. So the discretion on INEC is not as to transmitting and transferring electronically. That is settled. It is as to the electronic device that you use. BVAS, for instance, was an improvement to our first card reader. So the INEC needed not to go back to the National Assembly if they want to change BVAS to another updated electronic device. That is the discretion the law gave to them, not the discretion on whether they will transmit electronically. In any case, would you approve about electronic machine if there is no electronic transmission? What are you doing with it? Isn't it funny? If there is no electronic transmission of result, what are you doing with the electronic device? What are you doing with card reader? Are you using card reader to do the accreditation? If you don't have any use for the accredited results, you're using electronic device to store information and transmit. So if the law says no BVAS, no election, in other words, no card reader, no election, the law is simply saying no electronic storage and transmission of results, no election. So any act done that is not in accordance with this election process is void ab initio. There was no election. So it's unfortunate that the Presidential Election Petition Court went against the law in the issue of non-compliance, and that non-compliance was fundamental because it was a breach of the election process. What it means is that the unverified, manually collated result by INEC is not credible and should not be allowed to stand. Let me give you an example. Till today, INEC has not produced polling unit by polling unit result as demanded by law, section 62, subsection 2 and 3 of the Electoral Act. He said INEC should update the electronic register, polling unit by polling unit, and at the end of the day, anybody that wants a copy should be given the copy. Till today, it's not available anywhere. Like I gave you example, if you go to Edo, Anambra, Ondo, you still see the results uploaded. Not so with 25th February presidential election. So I want to tell you that till today, there is no election known by law that took place. And INEC has not shown anybody. I read mathematics. When I was in school, if they give you a question in mathematics and you just quote the answer, you will fail. They will even accuse you that you copied. The statement on how you arrive to the answer is more important than the answer you give. And it's those statements that gives you marks. INEC just came from nowhere and quoted an answer. No statement on how they arrived at it. And yet the court say it doesn't matter. The courts murdered justice. And justice is crying. And I pray that justice does not revenge on Nigeria. Now, the other issue the court said is about non-qualification of